So data is basically the currency of today's world, and it's a strategic asset for businesses. So pharma and biotech companies are not the first to the ballgame, and there have been other companies that can provide lessons learned to any industry, not just pharma and biotech. And I think the point of effective agreements, effective engagements with providers, and effective engagements with vendors is to take the learnings that have been done by those who have gone before, particularly those in regulated industries, and then apply them to the particular problems that we have here. So the short answer is the wheel does not have to be reinvented. People have invented the wheel, and now we have to put some different hubcaps on it. There is a distinction between best practices and best-of-breed practices. Typically, best practices mean you follow what other companies in your sector, your space, your industry are doing, and you compare your company with those peer companies. In an evolving world, I think it's better to use best-of-breed practices. So if all the companies in your peer group are relatively new to a particular endeavor or data practice, the risk is that you're measuring yourself against a lower standard and avoiding the lessons learned from other industries. So best of breed would be, if you're concerned with security of data, you look to the banks and the financial institutions, also regulated, also have this problem, and doing it longer. And therefore, rather than adopt what a peer company does, adopt what a leader in the field has done. Making something best of breed, as opposed to merely best practice, is having the professional advisors who have insight and can enable cross-fertilization from one industry to another industry. So part of that is identifying which industries and which companies within those industries are leaders, and then taking from them the practices that they use and applying them with appropriate changes to what your problems are. I think one of the big issues today is data ownership versus data sharing. And there's a tendency for people to say that they own the data, and what they're saying is two things. They own the intellectual property in the data, and they own some other right to make use of that data or to give that data to others under certain arrangements. The problem with data ownership is that in the United States, intellectual property provides a very thin set of protection. And the other more practical problem is almost all parties in the ecosystem think that they own the data. So an example, just to pick one out of left field, would be an airplane, where the aircraft manufacturer thinks they own all the data, the airline thinks it owns all the data, the company that makes the jet engines thinks it does, the company that makes the avionics thinks it does. And the law is not at the place yet where you could really sort that out. So let's look at it from what you really want to do. What you really want to do is make use of certain data for particular purposes within your context. So speaking as a lawyer, it's more important, I think, to structure use than it is to try and deal with kind of the metaphysics of ownership. And therefore, there are legal ways to do it. But skipping those legal ways, the way the agreements and business of the day-to-day use of data should be arranged is whatever data is in your data lake or your data pond or wherever you keep your big data. It's been contributed by different data custodians, and each company within the ecosystem needs the right to use the data. And the short answer is that use is more important than ownership, and the way you get there is through various licenses that put boundaries around the scope of the use. So privacy is a very big issue, especially with data that comes from multiple sources. And one of the big issues to consider is, do you have the right to use data from a patient for the purpose that you have in mind. And if you look at that, the conclusion is all privacy is contextual, because it depends on what the use is, it depends on what consent has been given, and it depends on what the upstream and downstream uses of the data are. If you take the example where a big box retailer sets up a hearing clinic, and then the goal is to have the patients of the hearing clinic walk through the door and buy the hearing aid from the retailer. The audiologist or the physician running the clinic needs to have certain amounts of information. But it's not binary. They only need the relevant information. And it would be disappointing, if not enraging to the patient, if irrelevant past operations that happened 20 years ago were transmitted. So what's the problem? The problem is somebody needs to go through the big electronic medical record and sort out what's relevant. And the further problem from that in an IT perspective is that kind of intensive work by human beings is probably not going to be fast enough to serve the real world needs. And therefore, there will be robots and very clever software that'll be able to make it less binary and more tailored to the particular needs. So the key issue is that what's private depends on the context, and the context is what data do you have, what are you going to use for it, what consent do you have, and what are the appropriate limitations. And this is both a legal issue and a set of expectations from the person whose data it is.